individually on behalf of the Texas Trial Lawyers Association. We had a very robust conversation about this last year, and I expected the proponents of the bill to bring us a litany of examples of how it's been abused and abused over the last 2 years here in Texas. That hasn't happened. You heard nothing about that. You know why? It's because several years ago we passed, or you passed, 2254 of the government code, which requires a state subdivision, a school district, a city, or a county to not only approve in a local vote by that body if they're going to hire lawyers to pursue an action like this, but after that, it has to go to the Attorney General to have the Attorney General's approval. That's what deals with cases like this, and that's a weeding out process that Texas has that other states don't have. I also want to make sure that you really understand what this does by looking at section, if you look at the limitation on common law public nuisance claims, it says there is no claim if the federal government agency or an agency has acted. That's fair, that's called preemption. But look what it says next. A state. So if California or New York passes a regulation or a law, it's going to preempt Texas law. You don't want to do that. We're not going to start creating state preemption by other states. It also says a state agency or a political subdivision. That's the New York City Council. They pass an ordinance or regulation, it would prevent Texas from bringing a public nuisance claim because some other state or some other city council, and even if we limited it here, you're going to let Lubbock tell Richardson what to do? I don't think so. So those are two problems. And if you look on the second page, it says regardless of whether a product is defective. So you're going to say there's no public nuisance, even in a situation where we acknowledge that a product is defective. Under this bill, you would not be able to pursue a public nuisance cause of action or remedy. I don't think that I would want to be in a campaign where I had voted to not allow a remedy for an acknowledged defective product. And finally, if you look, this bill at the very last, on line 23, it says if the agency has dealt with the conduct in a regulation, not that the remedy is adequate. So yeah, this bill talks about if a state agency has addressed the conduct, you can't bring a public nuisance cause of action, no matter how bad the damage is. So even if the adequate state agency, TCEQ, is inadequate, you would have no remedy because it dealt with the conduct, not the damage.
Thank you for your testimony. Welcome. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. My name is Jack Walker. I'm the president of the Texas Trial Lawyers Association. I'm here testifying today in opposition to Senate Bill 779. I'd first like to thank Senator Middleton for meeting with me and discussing the issues that we have with the bill. I will tell you this is the third or fourth iteration of the bill that's been before this body, and the bill has constantly been promoted based upon fear and not facts. For years, supporters of this bill have warned that if nuisance is not abolished, we're going to have a doomsday flood of frivolous lawsuits. This hypothetical parade of horribles has not happened and has not come to pass because Texas, as Mr. Eiland points out, already has an existing legal framework that would prevent that from happening. There's not a single case or example of a case being filed in Texas under some sort of preposterous or outrageous claim. The reality is that public nuisance claims are brought in cases of serious, widespread public harm, and it's precisely what this legal doctrine was meant to address. As members of this committee, you should always ask yourself two simple questions when you're considering a bill. Number one, who does the bill protect? And number two, who does it hurt? With regard to question number one, this legislation would protect large corporate wrongdoers from accountability for widespread harm that they cause to the public, because that's what this is used for. This bill would allow a company to negligently or even intentionally cause a public nuisance without adequate avenues of accountability. And who does it hurt? The bill would hurt the taxpayers and citizens of this state because it represents a form of corporate welfare, allowing companies to privatize very large profits while socializing the losses. If you eliminate the ability of the governmental entities to hold wrongdoers accountable for nuisance damages, taxpayers bear both the burden and the cost of these harms. Senator Hall, you picked up on something about this. Our future is uncertain. We don't know what the next public health crisis is going to be. We don't know what the next environmental disaster is going to be. But with regard to your question, that absolutely could be a public nuisance. If you had a farm that the generator somehow started generating large amounts of noise, okay, that's a regulated industry. Okay, under this bill, you can't file a public nuisance. But if it was a huge wind farm that caused, the noise was so loud that people couldn't sleep, it was bothering livestock and that sort of thing, that's a public nuisance that could not be brought under this bill. And that's what the danger of this bill is, the unintended consequences of the fact that the future is uncertain. And why remove this tool from the toolbox when it's not being abused in Texas? It is being abused other places. That's going to happen. California's going to abuse a lot of things that we don't. But Texas hasn't abused it, and this is a tool in the toolbox that should not be removed. Thank you.
And thank you for your testimony. Senator Schwerner has a question. You're right.
Thank you, Mr. Chairman. Thank you for your testimony. Regarding noise pollution, noise nuisances, the case of the windmill farms, but also in actually in my district, there's a natural gas compressor station which has a high-pitched whine that several neighbors have brought forth as a continuous problem that has not been addressed by that company. Is that a private nuisance that they can still have action on, or is that a public nuisance?
That is both, depending on the severity of the noise. You could bring a private nuisance cause of action against the company for that, but if it's widespread enough and the company doesn't respond to an individual who probably doesn't have the resources to fight the company, you've got the governmental entity with this tool would allow them to bring a public nuisance cause of action if the harm is widespread enough to stop that. When you say the governmental entity, are you referring in the case of a pipeline that would be the Railroad Commission or TCEQ or the state of Texas or the local DA? The local county could bring it. The local city could bring it. The governmental entity has that tool in the toolbox and could use it. Okay. Keep in mind that anybody can file a lawsuit for any reason. Okay. You still have to prove it up. Okay. You have in fact, our courts have a pattern jury charge on public nuisance that addresses that exact issue. Okay. Whether it's negligently done or intentionally done, okay, it still has to be brought, it has to be proved, and a jury or a fact finder has to make the finding. But it absolutely could be a public or a private cause of action depending on the severity of the noise and the harm and what you have in that case.
Thank you.
Thank you, Senator Birdwell. Senator Middleton, you're recognized.
Thank you, Chairman. Craig, a question for you. So obviously the tobacco, the opioid, those were brought into products liability, right? I mean, that was the main part of that. DTPA specifically with opioid, right?
And public nuisance on opioids by the counties and hospital districts.
But those had elements to them, correct?
Right.
And they were proved, right?
Right.
So you said earlier that this would remove people's ability to sue for a defective product.
Yes.
Yet we proved those elements, right? With both types of litigation.
Yep. Correct.
Right. So what you're saying is that this would remove people's ability to sue for defective products if they can't prove their DTPA claim.
This says you can't sue even if you do prove that it's an unreasonable product. You cannot sue
under public nuisance only. It does not prohibit you from suing under defective products, right?
Correct. Absolutely right.
Right. So, but what you were saying is this took away the ability to sue for defective products, but that's not true.
This says that you cannot use public nuisance, legal injury, or claim even if there is a defective product that caused it.
And basically what you're saying is when we're not able to prove the elements for DTPA, when we're not able to prove any of the elements for defective product, you want to still be able to recover outside of the statute of limitations too, right? Is this a run around on that? Is that y'all's goal?
No.
But you are aware that there's a statute of limitations of 15 years, right?
Yes.
Okay. And there's not with this, right?
I'm not following
With
that.
public nuisance. So outside the way it is now, there's not a statute of limitations, right?
In Texas, the way the Texas Supreme Court has addressed public nuisance as being a legal injury, and you still have to prove another cause of action, I would say that there is a statute of limitations because you still have to prove your negligence or defective product or whatever in order to get to the legal injury of a public nuisance.
So you're not left without a remedy.
If you pass this bill and there is a defective product, you do not have a claim for public nuisance damages.
But as an individual being harmed, you have a claim.
Oh, absolutely. This does not affect an individual's right. This just affects the state or the municipality or the county from addressing the damages caused to everybody. You would still have a claim as an individual for your own individual damages.
Okay.
But not for like the water supply.
And
Oh, thank you, Senator Middleton. Senator Perry had requested to speak, and then we'll recognize the need in the Senate.
May have just answered it, just in layman's terms, rural water supplier screws up, somehow or another pressure drops the line, people get sick. Is that going to require individual members in that supply chain to file claims, or does it still allow it to do under the statutory law as a group? You know what I'm asking? It's not a city system, which that's a different conversation, but truly a rural water supply, and there's tons of them, right? And they're all good people. They're all doing a yeoman's job, but sometimes people happen. So am I going to have to file this claim as an individual now under this law if it's passed, or can the group of people that were sick and because the chlorine went too low file the claim together? What would that look like under this bill?
If I can answer that.
Sure.
So public nuisance is defined as an unreasonable interference with a public right or public interest. And so you go back to the proof. It's an injury. Okay, so you would couple it with another cause of action, and what you would need to prove for volume of clients, customers, or the public is that that conduct interfered with a public right or public interest. It also could be a private nuisance cause of action. It really deals with the volume. And a better or another example would be, let's say it does happen to that instance happens, and you've got 40 people that were or 100 residents that are
Impacted.
affected. But then it somehow gets into the water table, or it somehow the pollution gets into the Brazos River, okay, and that spreads out. That goes from a private nuisance because of its size, to a public nuisance because of the definition of public nuisance. So that's where you can have both. But what we're doing here is you would create a situation where the private citizen who was affected could bring a private cause of action because they've got their damages and it was their yard. But the guy down the street or the subdivision down the street who's affected by the pollution from the Brazos River wouldn't be able to bring that same cause of action because the governmental entity wouldn't be able to do it. And so you create this issue where it crosses a boundary, it crosses a fence line, and you've got somebody that can seek redress, but then you've got the governmental entity who wants to protect the entire population, can't bring that cause of action for the same exact conduct.
That helps a bunch in my world. And, today in TCQ had a permit that was violated by a loophole today in Water Committee. We are addressing it now by statute. So as soon as we find bad actors that have exploited permits or done things that have affected people, we typically respond. It may be every 2 years, but we do get around to addressing those pretty quickly. But that scenario is real. Chlorine depletes and people have bad water. But to your point, to Senator Hall's point, I've got solar panels that have done some stuff and some way of leaching in different regions. So that water sift travels more than one person's property, right? So there's things like that out there that you're saying you still may get there, but it's going to be a different path and a little bit longer and arduous path.
It definitely could be, and you can take away the ability to capture all of the damages because that's what the public nuisance allows you to do.
I got you.
Because it's injury based.
That was helpful. Thank you.
Senator.
Thank you so much. And this is for anybody who would like to answer it. How would limiting the public nuisance claims affect the ability of Texans to protect their property, health, and local environment in general, and more specifically, wildlife, vegetation, and water resources?
I'm happy to answer that. It goes kind of part and parcel with what Senator Perry and Senator Hall have pointed out. Because it's actually injury based. Okay, it's a common law cause of action. It's been around for centuries, as we said. The use of it, for instance, in opioids, it was utilized in opioids to hold large, to hold very large companies, in fact, some of the largest accountable for the opioid crisis. The same thing can happen with regard to any environmental issue, and that's where I was talking earlier. We don't know what the future environmental crisis could be, but what we do know is that if it impacts Texas as a whole or Texans as a whole, the government, be it the AG, be it a county, be it any political subdivision, would not be able to utilize that to capture that injury. If you get rid of the injury, you get rid of the ability to cover the damages for the injury.
Thank you.
Thank you, Dean Safrarini. Senator Hinojosa, you're recognized.
Just a quick question, and I apologize if it's been answered already, but under the private nuisance part of this, as an individual in a case like where it's impacting potentially more than just one individual, could individuals come together in like a class action lawsuit and still under the private nuisance portion of this?
There are multiple ways that individuals can do it. They could actually probably bring a class action without nuisance, depending on what the case is. I will tell you that in Texas, class actions are very, very difficult to put together. There would probably, depending on the case, Senator, would be a situation where you would have a private nuisance, the ability to bring private nuisance even as a group, because it, again, and I'll read to you from the pattern jury charge, which is taken straight from the case law, that what you have to prove is that an unreasonable interference means that the defendant's conduct must be a significant interference with the public's safety or health, and the conduct must adversely affect all or a considerable part of the community. And that's where we get into the volume questions that I was talking about. So in answer to your questions, there can be private causes of action, and even groups get together and either individually or as an attempt to bring a class action.
But to be clear, this bill would not prevent those class action lawsuits from
private individuals for their private damages. No.
Right. And then one step further, if I may. So then, if a significant number of people who were impacted, such as a case of contaminated water supply or those kinds of things, would that not also trigger, if you had a significant class action lawsuit of people who are joining in, would that not also trigger these protections from TCEQ and other governmental entities?
You can have, it goes back to the example that I said about the fence line, okay? Let's say you had 40, 50, 100 people that were facing a contamination issue, and it was individual, but then it gets into the full water supply and affects the entire community. Okay? That's a public nuisance that can be brought on behalf of those individuals, okay, the public as a whole, to hold that wrongdoer accountable. And that's what the public nuisance.
But could it also be brought on by a number of citizens using the private nuisance?
Yeah, but they could only recover their personal damages. They could not recover the damages to the community at large. And that's what public nuisance picks up and allows you to do. If it affected my 20 acres, okay, and it killed my livestock, I can go sue them for a private nuisance and do it. But if it affects the entire community and contaminates a large portion of the water supply, and the damages are widespread, as it's said, and it affects the community as a whole, that's where the government entity is able to step in and bring a public nuisance cause of action. But in that situation, if the bill passes, the private person that has that happen to them individually can bring it, but the public as a whole would not be able to do it because the government wouldn't do it. It would create an imbalance of the inability to seek redress against what would be probably a large corporate malfeasance.